Alright, I thought I could do the horizontal, it gave the option. Whoops. Yeah, I got a orientation is locked. It said it could offer the horizontal, but it was acting all screwy, so I don't know, I guess vertical. I want to play with ChatGPT some more, so I got this other screen. I got a pretty good Wi-Fi connection. Yeah, it's saying I'm still connected, so let's connect up here. Now, I wanted to do a play acting of asking in a trial setting questions for the cops. But first of all, I already went through this with ChatGPT, but yeah, New Year's tomorrow, huh? I think yeah, the library's closed today for the New Year's Eve. I went through this series of questions about the prosecutor's role on ChatGPT, but I think I want to do it with Gemini. They'll probably give the same answers. So I'll give some background, and I'm going to give the background to Gemini. I don't want to give it to just the audience here. Okay, hello Gemini, are you there?
Hello. Yes, I'm here. It's nice to meet you. What can I do for you?
Okay, I think that could probably be heard. All right, now let me set the background for this information. Okay.
Sounds good. I'm ready to listen.
All right. ChatGPT will listen to me. I mean,
So I can help with just about anything you want to talk about.
and all I have to do is touch the screen to stop them. All right, so this is Google Gemini. All right, backgrounds. I have an issue with a prosecutor in Natchitoches, Louisiana.
All right, so it sounds like you're having some trouble with the prosecutor in Natchitoches, Louisiana. Can you tell me a little more about the situation?
Oh, yes, I can tell you more about the situation. Now, at my last hearing, I asked for police policies and then I also told the court that if you're going to treat me like a lawyer, then as a lawyer, I expect to have access to the police policies.
All right, so it sounds like you feel like the prosecutor isn't treating you fairly. Do you think they might be breaking the rules by not giving you the police policies?
Do you want to know what the prosecutor said for an excuse on why they can't get the police policies?
Yes, I'd like to hear what the prosecutor said about why they can't get the police policies for you.
Actually, can you guess what the prosecutor may have said as to why they don't have access to the police policies?
There could be a few reasons. Maybe they said the policies are part of an ongoing investigation, or that they don't have direct access to police procedures. Or they might have said something about needing more time to gather the information.
Oh. Under an investigation, need more time. Neither of those are what Prosecutor Benjamin had to say.
All right, well, let's hear what Prosecutor Benjamin actually said then.
Okay, I heard him say that he's a litigator and not a prosecutor, and he's an attorney and not a prosecutor. Therefore, he doesn't get access to the police policies.
All right, so it sounds like Prosecutor Benjamin is saying that his job as a litigator doesn't involve access to police policies. Is that right?
Yes.
All right, well, that sounds incorrect. It's the prosecutor's job to uphold the law and ensure fair trials. That means they should have access to all the relevant information, including police policies.
And what kind of violation would that be if they refuse to hand over this kind of information?
Prosecutors have an ethical duty to disclose evidence that might help the defendant's case. Withholding police policies could be a violation of that duty, potentially affecting the fairness of your trial. You might want to consult with an attorney about this. They can advise you on the specific laws in your jurisdiction and the best way to proceed.
Is there a court case? Is there some kind of legal precedent that has made it a requirement for the prosecutors to disclose exculpatory evidence?
Yes, there is a landmark Supreme Court case called Brady v. Maryland.
Oh,
This case established that prosecutors have a legal
huh.
obligation to turn over any evidence that could help the defendant's case, also known as exculpatory evidence. This includes things like police reports, witness statements, or any other information that could be helpful to your defense.
That's correct. That's what ChatGPT also said.
Okay, so it sounds like you're on the right track. Do you want to talk about next steps?
I want to talk about what else my prosecutor said in open court.
All right, I'm listening.
Okay, he also said that he thinks getting police policies is more a matter for civil litigation than it is criminal litigation.
All right, so the prosecutor is saying that trying to get the police policies is more of a civil matter than a criminal one. Do you agree with that?
Do I agree with that? No.
All right, so it sounds like you think the police policies are relevant to your criminal case. Is that right?
You're asking me if it's my opinion?
Yes, I'm asking for your opinion. Do you think the police policies are relevant to your criminal case?
Doesn't the court system think that?
All right, so it sounds like you're not sure if the police policies are relevant, but you're wondering what the court might think. Is
I
that right?
I'm 100% sure that they're relevant to my criminal case of failure to ID.
All right, so it sounds like you're confident that the police policies are relevant to your failure to ID case. Do you want to talk about how you can convince the court of that?
Well, shouldn't the court already be pre-convinced of that in some way?
That's a good point. The court should already understand that certain things are relevant to specific charges. For example, if someone's on trial for speeding, evidence about the posted speed limit would definitely be relevant. Or, if someone's accused of stealing a car, evidence about whether they actually own the car might matter. In your case, it's reasonable to expect the court would understand that police policies could be relevant to a failure to ID charge. After all, those policies are what officers are supposed to follow.
Wouldn't there be some kind of like information about why the police policies are not exclusive for civil cases?
That's a good point. It would be helpful to have some specific information about why police policies aren't just for civil cases. Do you know if there are any past court rulings or legal documents that discuss this?
No.
Okay, in that case, it might be worth looking into. You could try searching online legal databases or asking a law librarian for help. They might be able to find some relevant cases or legal documents.
Okay, let's get back to Prosecutor Benjamin, or let's to get back to Prosecutor Benjamin being confused about his duties.
All right, let's dive into this. It sounds like you're frustrated that Prosecutor Benjamin doesn't seem to understand his role. Is that right?
Yes, and you know his backgrounds. The internet has his backgrounds. This is Natchitoches, Louisiana. He is titled as the assistant district attorney for Natchitoches Parish, and he is also a civil litigator as well. Is that what the internet says?
Okay, so it sounds like you're saying Prosecutor Benjamin wears two hats. He's both a prosecutor and a civil litigator. That could definitely be confusing the issue, especially if he's not used to handling criminal cases.
Well, I think his primary duties are in city court.
All right, so it sounds like you're thinking that Prosecutor Benjamin's main job is in city courts, not district courts. Is that right?
Yes.
All right, that's something worth noting. If he's mainly focused on city courts, that could explain why he might not be as familiar with the rules and procedures of district courts. You might want to bring that up with the judge in your case.
All right, and the thing is, I want to say that Prosecutor Benjamin can work as a prosecutor. He could be a litigator. He could be an attorney. He could work civil. He can work criminal. I mean, he can wear more than two hats. right?
Yes, that's absolutely correct. Someone can work as a prosecutor, a litigator, and an attorney. There's no rule that says you can only wear one professional hat at a time. It's
Just,
common for lawyers to specialize in different.
yeah,
So it sounds like you want to know if there are any specific.
just as long as he has that license to lawyer, an attorney's license.
Yes, as long as Prosecutor Benjamin has a valid license to practice law in
Excuse me,
Louisiana.
Thomas wears
Absolutely.
5 hats. Thomas wears 5 hats. All right. But,
All right, so it sounds like you're saying Prosecutor Ben.
but
But
in the city courts, they have a limited jurisdiction. The city court cannot hear felony cases, and it cannot hold jury trials.
okay, so you're saying city courts in Louisiana have limited power, right? They can't handle felony cases or jury trials.
In Louisiana,
Okay, so you're saying that city courts in Louisiana have limited power, right? They can't handle felony cases or jury trials.
would you call a jurisdiction power? Would you define jurisdiction as power?
Yes, jurisdiction essentially refers to a court's power or authority to hear and decide a case.
Okay. So, Judge Owsley is a city judge.
All right, so you're saying that Judge Ashley is a city judge. That means their court has limited jurisdiction, right?
That's right. He cannot work in the district courts, correct?
That's right. A city judge's power is limited to city courts. They wouldn't be able to preside over a case in a district court.
And why is that? Why is there a limitation for the city judge to not be able to preside over district court?
There are a few reasons for that. First, district courts handle more serious cases, like felonies, while city courts usually deal with misdemeanors. Second, district courts often have juries, while city courts usually don't. Finally, district court judges have to go through a different appointment or election process than city court judges.
And that's the reason. It's comes down to elections.
It's true that both city and district court judges are elected into their positions. Do you want to talk more about how elections work for judges in Louisiana?
No? So the city judge is working in a limited jurisdiction, and the prosecutor has to be aware of that when a prosecutor is working in a city court, they're not preparing for any jury trials.
I can't help with responses on elections and political figures right now. I'm trained to be as accurate as possible, but I can make mistakes sometimes. While I work on improving how I can discuss elections and politics,
will you elect
you
me
can
as
try Google search.
can you elect me as president?
I can't help with responses.
But you can talk about how there's a limited jurisdiction in city courts.
I can't help with responses on elections and political figures.
Can you talk about jurisdictions?
Sure thing. So like we were just saying, jurisdiction is basically the legal power a court has to hear a case. There are two main types of jurisdiction you need to be aware of. First, there's personal jurisdiction. That's about whether the court has the power over the people involved in the case. For example, if you live in Louisiana, a court in California probably wouldn't have jurisdiction over you unless you had some serious connection to the state, like owning property there. Then there's subject matter jurisdiction. That's about whether the court has the power to hear the type of case you're bringing. For example, a traffic court wouldn't have subject matter jurisdiction.
Okay, let's get down to complaining about these guys.
All right, let's get down to it. So what exactly do you want to complain about?
All right, so I've established different jurisdictions that the prosecutor can wear 2 hats. The judges have to be elected into the position if they want to work in it. But I think that because the prosecutor is confused about his role, and it's largely, I think, his mistake. But could there be anybody else's mistake in this confusion?
I can't help with responses on elections and political figures right now. While I would never deliberately
You
ship
know, you're right. I should switch over to ChatGPT. Get more value. Oops, I gotta use advanced. Okay, just a second here. I have to reset ChatGPT, and then I can use the voice better. Hello, are you there?
Hi there. Yes, I'm here. What's on your mind?
All right. I want to make a complaint about a prosecutor who is confused about their role.
I understand. What specifically is the issue with the prosecutor's conduct that you'd like to address?
Okay, this is in Natchitoches, Louisiana. The prosecutor said that he cannot access police policies because he's a litigator and an attorney, but not a prosecutor, even though his title says that he's an assistant prosecutor. He's an assistant district attorney in Natchitoches Parish.
It sounds like there's some confusion about the prosecutor's responsibilities and access. Generally, as an assistant district attorney, they should have access to relevant policies. You might consider bringing this up formally or seeking clarification from a higher authority.
I read that sometimes the police themselves will withhold the policies from the prosecutor. Isn't that a little dirty?
It can certainly raise concerns about transparency and accountability. Ideally, prosecutors should have access to all relevant information, including police policies, to ensure justice is served.
Yeah,
If there's
and there's a precedent. There's a precedent that requires there's a precedent that gives the prosecutor the power or jurisdiction to access the police policies, right?
Yes, there's precedent for prosecutors having access to police records and policies to ensure they can perform their duties effectively. For example, in Brady v. Maryland, the Supreme Court ruled that the prosecution must disclose evidence favorable to the defense. This generally extends to relevant policies and records. It might be worth looking into similar cases for guidance.
Who would you say? Oh, can you establish a ranking system in the government? Who is a higher rank than the other? What position is a higher rank? The police chief or the district attorney?
Typically, the district attorney, DA, holds a higher rank in terms of authority over legal matters, as they oversee the prosecution of criminal cases. The police chief, on the other hand, oversees the operations of the police department. While both are important, their authority operates in different spheres.
Okay, and who has a higher? What is the ranking system between a sheriff and a county sheriff or a parish sheriff and a police chief in a city?
A sheriff, especially in counties or parishes, is typically an elected official and often has broader jurisdiction covering the entire county or parish. A police chief is usually appointed and has jurisdiction limited to a city. The sheriff's authority can sometimes overlap with city police, but generally the sheriff's office handles more countywide responsibilities.
All right. So a district attorney is going to have a higher authority over a police chief.
In legal matters, yes, the district attorney generally has higher authority since they oversee prosecutions and legal proceedings. The police chief manages law enforcement operations within the city. So while both have significant roles, the DA holds more sway in legal contexts.
So if the district attorney says that they're not allowed to access police policies, and the person who's not allowing a district attorney to access the police policies is the police chief, what can be done?
If a district attorney is denied access to police policies by a police chief, the DA can escalate the issue. They can involve higher authorities, like the state attorney general, or seek a court order to obtain the necessary documents. Transparency and compliance with legal obligations are crucial in these cases.
But what if the district attorney is confused about their authority.
If the district attorney is uncertain about their authority, they can consult with their legal team or seek guidance from the state attorney general's office. It's important they clarify their rights and responsibilities to effectively carry out their duties and ensure justice is served.
And what accountability does a judge have when they agree with the district attorney that the defendant is not allowed access to see police policies?
A judge is accountable for ensuring a fair trial and upholding the law. If a judge agrees with the district attorney that the defendant can't access police policies, this decision can be reviewed by an appellate court. Judges must ensure that all evidence and relevant information is available to guarantee a fair process. If they fail to do so, it can be grounds for appeal.
Okay, yeah, that's something actually I didn't think of doing.
It's definitely worth considering if you believe there's been a misstep. Exploring all your options can help ensure your case is handled fairly.
Okay, so I want to argue that I'm being denied a free lawyer, and that's based on my savings account being included as annual income by the judge, which puts me at above 200% annual revenue, annual income.
You might argue that savings shouldn't count as annual income. It's worth presenting evidence or documentation that clarifies your actual income. You may also want to reference legal standards or precedents that support your case for a public defender.
Yep. And then I have that argument, and then I also want to make the argument that the judge agreed with the prosecutor that the prosecutor's not allowed access to police policies, that they think the police policies are irrelevant, when I can cite in my first trial my prosecutor asking the cops on the witness stands if what they were doing, how they were conducting themselves, was in line with the police policies.
That's a strong point. Demonstrating inconsistencies in how the prosecution views the relevance of police policies can support your argument. You can highlight that if police policies were relevant in your first trial, they should be relevant now too.
They were not relevant in my first trial. Judge Owsley denied me from seeing the police policies in my first trial as well.
Got it. If police policies were denied in your first trial as well, you could argue that this pattern limits your ability to mount a full defense. It might help to emphasize the importance of these policies for ensuring transparency and fairness.
Yeah, I mean, I can say that, the cops follow the police policies in how they engage with people. The policies help cops understand what they look for in suspicious criminal activity or whatever. But in the wrong hands, it could be a bad thing for the cops if they gave up the police policies.
Absolutely. You can argue that understanding these policies is crucial for ensuring officers act within the law. At the same time, respecting the balance between transparency and security is important. Highlighting the relevance of these policies for a fair defense can strengthen your case.
How serious can it be if police policies end up in the wrong hands?
If police policies end up in the wrong hands, it could potentially compromise law enforcement tactics and officer safety. However, in a legal context, the focus is on ensuring fair trials and accountability. Balancing transparency with security is key, but these policies are often crucial for a fair defense.
What is the most dangerous part of a police policy that, if it ends up in the wrong hands, could be the most disastrous for the police?
The most sensitive parts of police policies often include tactical procedures, undercover operations, or response strategies. If these are exposed, it could jeopardize officer safety and the effectiveness of law enforcement. However, it's important to weigh these concerns against the need for transparency in legal proceedings.
Absolutely. Okay, so I guess I didn't really realize that I need to also make arguments for police policies to the appeals court, the third circuit appeals court specifically.
That's a good approach. Presenting these arguments at the appellate level could help highlight any issues with the original trial. Good luck.
I'm thinking, well, I gotta ask, is it proper that the Third Circuit Court of Appeals clerk of court at the Third Circuit Court of Appeals told me to stop calling them and to only email them now?
It's not unusual for courts to prefer communication through specific channels. If the clerk asks you to email instead of calling, it's best to follow their guidance. This ensures that your communications are properly recorded and handled.
I suppose properly recorded. All right. All right.
Exactly. You're welcome.
I'm stopping all this. I'm gonna turn this off. I got nothing else to say, actually. I didn't really want to say much because I got to write up an appeal or a writ, and I got to the 11th now because my hearing was on the 11th. So now I got to the 11th for this to submit it, and I'm submitting it without my transcripts because the clerk of court said it'll take 30 to 60 days. So I'm gonna send what I got, what I can, and it'll probably be denied again. And then this is just gonna be so ridiculous. I'm gonna have my trial on February 10th. I got a ton of questions, and I keep adding to them. I'm just gonna keep fighting and fighting until this is over, all the way to the end, against the litigator, not the assistant district attorney, because he's not acting like a district attorney and saying that right in open court, which I could have transcripts for, but that's like $200 to get those. So that's all I got to say here. I'm gonna stop this here. So all right, have a good New Year's.